the Japanese criminal procedure under the status quo. Next. Oh, now, this chart shows the current situation of criminal justice in Japan. Let's look at this chart. First of all, this is a murder case, current issue, current situation. This red line shows us arrested rate. In murder case, when the man offender committed the murder, but almost the murders were arrested. The ratio is 99.5%. 99.5% murders are arrested by police. And the blue line and green line here is, but green line is a number of the recognition of murder in 1 year, and green line is arrested number in each year. So 2 years ago, so for example, 2 years ago is the number of recognition of murder is 900 cases, and arrested cases, the number of arrested cases is almost the 900 cases. So yeah, the arrested rate is almost 100%. How about the injury, bodily injury? The rated arrested rate is 84.9%. So it is, we can say that in the case of bodily injury, the almost offenders are committed by police. The other criminal cases, the threat and the robbery and the assault, the fraud, and the so-called life and the bodily cases, the robbery and the assault, is the arrested rate is very, very high. You see, and the threat case, okay. The next is this chart shows us the comparison among developed countries. Here is Japan and Germany, United States, France, and England, and Japan. And here is the number of occurrence number, arrested crime, and this is a ratio. Is occurrence ratio, number per 100,000 people. So among 100,000 people, how many cases of murder occurred? For example, 2017, the number of murder is 306 cases occurred, and arrested ratio is per 100,000 is 0.2. How about Germany, the 1.0, and the United States is a murder case occurred, the 5.3 cases per 100,000. France is 1.3 and England is 1.2. So we can say that Japanese murder case is a very, very few when it comes to comparing with the other developed countries. This is a murder case, no? And next is robbery case. Robbery case is also same thing. So Japan is 2060. The occurrence rate is 1.8 per 100,000. Germany is 52.3, and United States. So for example, 2070s. The 98.6, so the France is look like this, and England is like this. So in the robbery case, is Japan is very, very few in other countries when compare with other countries. So we can say that Japan is a very, very safety country in terms of the criminal when it comes to comparing with the other developed countries. So we can say that, okay, well, if you come to Japan as a tourist in the midnight and walking alone in the midnight, even if in the midnight alone walking, but of course there is no, we can say almost no to meet the crime. But of course, States is a very, very dangerous country in terms of the criminal. The occurrence rate is very, very high. You see, Haraman, here is a question from you, from me. How about Indonesia?
Maybe we have more people, citizens. There are many mother. If you read the newspaper in Indonesia,
it depends on this.
Yeah, many case of the mother and yeah, robbery, especially robbery not the enter the house, but robbery for the motorcycle in the street. Many of the robbery in the street, you know. Murder, maybe we like is more high than Japan, of course. Yeah.
How about Jakarta? Bengkulu is rather relatively safe.
Kulu relative safe place, you know. It's not too big city. We have a middle city. We have only 1 million people stay. 1.5 million people stay in this prefecture.
Really? Good, very good.
Yeah.
And I myself, I have I met the assault during staying in Germany. From 1998 to 2000, I ran in Germany for 2 years. At the midnight, I got on the straight train in the midnight, but extreme right wing came to me, and I attacked. I attacked in the train. So Germany is relatively safe in compare with other European countries, but nevertheless, I have attacked. So Germany is not so safety country. Okay.
Yeah, but in the public transportation, like train, in Indonesia, we have some guard, you know, train guard. Every maybe for one train we have 2 guard, you know. It's more safely stay in train, but outside train, this is a problem, you know. Yeah.
Okay, the next chart is next data is trial period in Japanese criminal justice system. I will explain about the structure of criminal court later on, but before that, I want to touch upon the trial period. The Japanese criminal justice criminal court has a 3-tier structure: the first instance, and the second instance, and the Supreme Court. And the first instance, the case is solved. This number shows us the period to the end of the resolution of the case. So within 1 month, 44.8% is resolved in the first instance, and 58.6% was resolved at the end of the first instance. The 25.3%. Of course, so we can say that almost 80% was resolved in the first instance. And of course, defendant or prosecutor had against the sentence or conclusion of the first instance, they can appeal to the higher court. The first instance to the end of the second instance, if the prosecutor and the defendants appealed the second instance, of course, it is rather wrong, but even if the defendants or the prosecutor goes to a second instance, the case will be the case was resolved within 3 months and 6 months and 1 year and 2 years and 6 months and 30.44%. And within 1 year, the 43.4%. So 73.8% were resolved in the second instance. So we are not so we don't need so long time to resolve one case. The next chart is from first instance to the end of the Supreme Court. That means the first instance to end of the Supreme Court, at the top of the Supreme Court, the case. Within the 1 year, 49.4%. And within 2 years, 39.1%. Even if the defendant or prosecutor appeals against the first instance conclusion and the second instance conclusion, and they appealed the Supreme Court. But of course, the time, the examining time is rather long. But even if so, almost 80% of all of the case are resolved in the Supreme Court. And besides, the more important point, we have the more important point in the Japanese criminal justice system. The number of persons who was judged is 299,319. The number of persons who was judged as not guilty is only 130. So the ratio of guilty rate is not guilty rate is 0.04%, and the guilty rate is 99.6%. So if the defendant are charged and prosecuted, and he must be almost must be sentenced by the guilty. So guilty rate is very high. This is a very big and important character of the Japanese criminal justice system. How about the Indonesian's criminal justice system? How many percent of the guilty rate in your criminal court in Indonesia?
Yeah, almost a case should be punished by a court. Maybe we have a little number concerning the not guilty rate. Yeah, maybe we use the criminal crime control. Yeah, that's the if the police not believe the person will punish by court, the police cannot send the case to prosecutor. Of course, the prosecutor will select the case. If he don't think this will be punished to the court, they not sent to the court.
So
I think
prosecution has the power to select the case.
Yeah.
It's the same as Japan.
Yeah.
And besides, for example, the United States, the guilty rate is about 80%, and Germany is also the same as the 80%. So 20% is not guilty, but 80% is guilty. So Japan is very extremely very low, and guilty rate is very extremely high. So that is the character of the Japanese criminal justice system. Next, so estimate to the criminal justice system in Japan, we can say that social peace and order, so we are safe or not. So of course, the Japanese society is a very safe in terms of the criminal, or there is almost no possibility to meet the crime. So of course, when the women only one and only the alone for okay. Next is the speedy trial. Next is the speedy trial. The trial the period is a very short, so not so long, so very good. The speedy trial is carried out. And the third point, the certainty of punishment. So of course, excellent, because the guilty rate is very high, 9.6% is a very good and excellent result. So for to tell the truth, the prosecutor or judges or members of are very for and proud Japanese criminal justice system. Yeah, please show me. Please show us the Japanese criminal justice system. Please come Japan to reach they say the foreigners. But I'm anxiety about this result. But really, the problem is the quality of criminal justice system. We have to examine the number of the criminal justice system, not number, the quantity, but quality. Quality of the criminal justice system is a real problem. I will explain about that later. The proceeding of criminal procedure. I will explain about the proceedings of the criminal procedure. If the murder case is occurred and the victim is died, this is the murder case. And first of all, the first steps and the first of course, the police gathers the evidence. Of course, police arrested the offender. This is the investigation stage. This is a very important target in the investigation stage. And the next stage is, what is the next stage? Is prosecution. The prosecutor decided whether this case and this officer must be executed and go through the criminal court or not. So of course, yesterday I explained, even if the murder case occurred, but the crime offender is not insanity, mental disease, they had the mental disease, the prosecutor can't prosecute him because the liabilities, the culpabilities is lack of culpability. Because of lack of culpability, so they can't prosecute anymore. But of course, the murder is no problem. They should be punished. The prosecutor decided, yeah, he must be punished. So I decided to prosecute him. The next stage is preparatory process in criminal court. Before starting the trial, and the prosecutor and the attorneys meet in the court and to arrange and to examine the dispute point. Dispute point is, for example, no, he is not murdered. This is arrested. He is not guilty. And the prosecutor says, no, you made a mistake. He is a real offender. We don't made a mistake. And the lawyers, attorneys, investigation had a mistake. He is not the real offender. So or his lack of culpability at that time when he killed the victims. he had no culpability because he is mental illness. So lack of culpability, he is not guilty. For example, prosecutor and attorneys meet in front of the judges. They have to plan the proceedings in the trial. And next step is, of course, the main role of the criminal procedure. The trial starts. In the murder case, I will explain about the裁判員 system in later. In murder case, it's a very serious case, criminal case. So 3 professional judges and 6 lay persons gathered to decide that he is guilty or not guilty. This is the裁判員 system, and this is the trial. This is the trial style in murder case. And after that, the prosecutor and attorneys prove and claims and express his opinion. And after that, the judgment is carried out. So not guilty or not guilty. And before, as I said before, the Japanese criminal justice system, the guilty rate is 99.60% as a result. This is a procedure of the criminal procedure in Japan. The same as Indonesia.
Yeah, but we have no limitation for the time of the for example to investigation instant. No limitation to the prosecution instant, you know. Yeah, but we have a time, we have limitation time to have detention. In investigation state, we have 120 days to detention the offender in investigating state.
Really? 120
yeah.
days.
120
days.
120 days for the investigation state. This is the maximum day the investigator, the police officer, can detention the offender. But the regulation say this is maximum. That means if the investigation is finished, of course the police should be released the offender. But in practice, the police will wait until the maximum time is finished. Yeah.
Okay, next chart. Let's go to the next chart. This is a criminal justice system in Japan. As you see, we Japan criminal justice court had a 3-tier system. The top of the court of the Supreme Court, and the next is the High Court, and the District Court, and the Summary Court. We had this structure. And of course, the serious case, in the serious criminal case, starts from district courts. And the summary court is not so serious and not so serious damage in the criminal case starts from summary court. But of course, the general criminal case starts from district court, murder or robbery and theft and fraud and other relatively serious case started from district court. And the district court, the conclusion of district court is again, the relative person in the case is against the conclusion of district court. They can appeal the High Court. And even if the High Court, they against and the conclusion of High Court, they can go to Supreme Court. So we Japanese have a chance, 3 chances to examine the criminal case: the district court, and the High Court, and the Supreme Court. And the juvenile law, the juvenile case is the family court. But today, I don't explain about the juvenile law. We are talking about the criminal procedure mainly. So in the not serious case, that case is start from summary court, the summary court and the high court and the Supreme Court. Anyway, we have three steps, three chances to examine on criminal case. This is the same in Indonesia, almost same. This is a structure almost same as Indonesia.
No, I don't understand concerning the family. No, in Indonesia we have only a Supreme Court and this court that have no family court. What the family court of and Supreme Court is main branch in the Japan.
Really? Okay.
Yeah.
And this is Supreme Court building, and this is the court itself, the High Supreme Court. In Supreme Court is 15 judges, but the case is a very, very serious case. It's 15. All of the judges of Supreme Court is gathering to discuss, to decide, to judge. But in normally, the big court is divided into three parts. The first and the second three, and in normal case is the Kuliah and the little court. In the little court is the case examined, and this is the High Court. This is the Tokyo High Court and the Sapporo Court and the Sendai, Nagoya, Hiroshima, Osaka, and Takamatsu in Shikoku, in Kagawa Prefecture, and Fukuoka. We have 8 high courts in the all over Japan. And structure of the criminal court. The only professional judge style in the not serious criminal case. The only professional judges are examined, connected to with and this is a prosecutor, and she is attorney, and he's a clerk, and he's a stenographer. It's a very basic structure of this criminal justice court, criminal court. For example, the not serious criminal case is only professional judge style. In the only professional judge style, the case is examined. But here is a professional, but the members only, and he is selected. He is by lot. Of course, he is right to election. Citizens who have the right to election, the parliament, politicians, by lot is selected. 6 members, and 6 citizens and 3 professional judges are taking the serious case to examine. And this is a prosecutor, and this is attorney. Of course, the stars and the stars means German. The stars means states. Amber means wait a minute. Wait a minute. Representative. Representative. The star number means states representative. The representative from states. The list number means list is justice or law. The amber means representative. The list number means the justice representative or laws representative. So of course, the attorney is praying to protect the right of the defendant or right of the suspect. The prosecutor play a role to maintain, to keep the social peace, social order. Excuse me, do you have citizens taking part in Indonesia, like jury system in United States?
Oh, no, we have no ordinary people that's selected. That you mean? The trial conducted by only the professional judge. We have 3 or 5 or 6 judge for one chamber. But we have different too. The exercises of stenographer
Legal pressure for say England, Germany, France, in comparison with the number of these parties. The attorney, the number of attorney in Japan is 40,066. Judges 2,782. Prosecutor is 1,957. USA is like this. And the judges, this is a state's judge, and this is a national judge. And the states, this is number of states judge, and the prosecutor is the national prosecutor, and this number is state's prosecutor. England is like so, and Germany is like so. It's like so. So this is very, very few in the hand of this, and the prosecutor is also very in other European countries. Now, France, the real profession is very fewer than other European countries. So this is one of the most important. This is a serious problem because the people, Japanese people, can't enjoy the legal service. People requires to increase the number of, especially a judge or prosecutor. The judges or prosecutors' burden is very heavy. How about Indonesia? How many attorneys or judges or prosecutors?
Yeah.
Enough? Not enough?
No, not enough. In this year, the prosecutor general will appoint concerning 1,000 new prosecutor. Yeah, we have the big, because we have big land, you know. The big land is many different geography. That we need many of prosecutor and many judge. And the today follow you lecture is some of judge. Yeah, they follow this lecture. They are maybe 4 judge and prosecutor and the police officer, the chief of police officer in this Bengkulu region, and the attorney. Completely prosecutor to follow your presentation today. They are all is our student in Magister Master of Law in this faculty.
Really. Of
Yeah.
course, of course, the population of Indonesia is more than Japan. I've heard the Indonesia's population is 200 million.
Yeah.
Million, huh?
More. Yeah.
Mm. Okay, the next chart. Current issue of investigation proceedings. Sorry, usual. Now, under the status quo, we had reformation of an investigation stage. First of all, the expand of the public defense system, in short, in PDS. Before 2004, the PDS applied after prosecution. And after the stage of the prosecution, in trial, the very poor defendant can get the defendant, public defendant. But it was not enough to protect the right of the defendant. So 204 criminal procedure law reformation, the public defense system, public defender from investigation, the defendant, the poor defendant can get the support from attorneys as a public defender. So during the integration by police, during integration by police, the suspect can get legal service from attorney. Yeah, you see. So of course, to protect the right of the suspect, he can get the legal service from the attorney as soon as possible. So, to do so, after in 2004, the criminal procedure law was reformed, and the public defender system are introduced from the stage of the interrogation. So a guarantee of the right to the consult with attorney. This is a very, very big change in 2004. This is a very good reformation. So this chart shows us, I'm sorry in Japanese, but sorry. So the green belt is shows us the number of cases. The 2090s, the criminal case is 50,000 cases occurred, and 60.5 the public defenders came to the defendant to consult, and this is a private defender. The rich defendant, and the rich suspect must get the support in private, support from the defender in private, because they have money. But of course, the lots of defendant and the suspect don't have enough money. So to protect such a poor suspect and defendant rights, the public defenders the system are introduced. So the ratio is very, very increased. So now the 60.5% of suspect and the defendant can get the support from the public defender. So this is a very big change in under the status quo. Yes. And second is reformation is this is a very sorry. Sorry. Video camera recording system in integration. Can you hear me?
Yeah. Okay.
2060 criminal procedure reformation. The police and the prosecutor's obligation, as the police and the prosecutor's obligation, integration against certain crimes and the insanity case, 2090s, the video camera recording enforcement is carried out. So policemen and the prosecutors must record the integration situation by video camera recording. This is a very, very big change in the history of the Japanese criminal procedure. Like this, during the interrogation, the policeman, and this is the suspect. The policeman asked, had several questions to the suspect. The suspect answered, but here is a camera, and this is recorded apparat. So the examination and answer, question and answer, the situation must be recorded, and video cameras recorded. At the beginning of the debate, whether the camera or video camera recording system was introduced or not, the policeman or the prosecutor are very strongly against that, because if the camera or recording was carried out, it is very difficult to proceed the interrogation. But now, Japanese government decided to introduce a video camera recording system to do very correctly, and very correctly the proceeding, the interrogation. This is also the big change in the criminal procedure law. Yesterday, I said that to establishment the crime, the objective elements of the defendant's justification and culpability is the very 3 steps are needed, the field to establish the crime. And if each element, one of each elements is lacked, it is not crime. So most important point is in the criminal procedure is a correct fact finding. If the judge or prosecutors or police make a mistake, it leads to a misjudge. So the criminal procedure laws professor is very strongly examine this the criminal procedure is good or not in terms of misjudge or not. For example, to carry out the correct fact finding, we have a very important rule in criminal procedure. First of all, the due process of law. Of course, I know. Of course, in Indonesia's criminal procedure, the due process law is determined and written. And the Constitution, Japanese constitutional law, Article 3, no person shall be deprived of life or liberty, nor shall any other criminal penalty be imposed except according to procedure established by law. This is a very important point, the due process of law. The presumption of evidence. This is also a very important principle in criminal procedure law and in Constitution. The presumption of evidence is a legal principle that every person accused of any crime is considered innocent until proven guilty. So this is a very important principle to examine and to think about the criminal procedure law. And the most important point is to fact-finding rule. So first of all, we had those principles, proof beyond a reasonable doubt. In Latin, in dubio pro reo, the Article 380, the probative value of evidence is left to the free discretion of the judge. The judge can decide whether this defendant is guilty or not guilty. And the value of evidence is the judge have to examine the value of evidence, but freely. They have power and discretion. This evidence is very enough or not enough. But of course, free discretion doesn't mean the arbitrary judge. This is prohibited. Of course, the free discretion means no one can deny that this defendant is guilty. No one can deny. The standard of proof is very high. And the second fact-finding rule is exclusively rule of confession. The Constitution says that no person shall be compelled to testify against himself, and the confession made under compulsion, torture, or threat, or after prolonged arrest or detention shall not be admitted in evidence. This is a very important point and important role. Do you have the same principle in Indonesia's criminal procedure or constitution?
Yeah, yeah. We of
Okay.
course have some rule concerning that fact-finding rule. Investigation state, in the court state, we have the norm like this. Yeah.
Of course, the criminal procedure law is also sets 390 confession under coercion, torture, threats after unduly prolonged detention, or when there is doubt about the said confession being voluntary, may not be admitted as evidence. If the confession is not voluntary, that the evidence is not prohibited. Those confession is not prohibited to bring up the court. This is a very important point. I've heard the Haraman-san, my friend Haraman, I've heard 2 years ago in Indonesia's police, in the integration, they use the snake against the suspect. This is a Newsweek article of Newsweek I've heard. It is true.
Yeah, in regulation is prohibited, but in practice, some of our police officers use the torture like that to take the suspect out. Yeah, like now, we have some big case concerning the COVID-19, and one of the famous religion leader will become suspect, and many now the police officer sue become because he murdered the suspect. Yeah.
Okay.
Yeah.
You said incorrectly. To tell the truth, we are saying, we are explaining about the principle, but theoretically, it is very good point. But in practice, the Japanese policeman and a very strong power against the defendant and the suspect, that during the integration, there is a lots of serious case to threat or coercion or there is a lots of problem in the Japanese police also. And then the next principle is a collaboration rule. This is my the studying theme. The Constitution, Article 38, that no person shall be convicted or punished in cases where the only proof against him is in his confession. Next is Article 9, and this is the Criminal Procedure Code. The accused may not convict it when the confession, whether it was made in open court or not, is the only piece of incriminating evidence. That means very important. That this is also their very important principle. That means like this. If the investigation, the police and the prosecutor got the only evidence as evidence, confession, it is can I judge decided the guilty? This is not. This is prohibited. The judge can't decide the defendant guilty. This is prohibited. If the investigation, the policeman and the prosecutor get the confession and accept for the confession, other evidences is needed. The evidence, the expect for confession, for example, the knife or the diary or eyewitness, the exception for confession that is needed. So if the confession and evidence exception for confession, the policeman and prosecutor gathered these evidences, the judge can get judge can decide the defendant is guilty. This is a very important point. This is a collaborative rule and collaboration. This is my studying theme now.
That some regulation that forbidden the evidence get evidence from confession is prohibited in the regulation.
Yes.
Yeah.
And the hearsay rule. The hearsay rule is very, very to explain, difficult to explain. Of the hearsay rule, do you have heard the hearsay rule?
No, like the I forget that.
In Japan, we have a criminal procedure, Article 320. No document, no statement of another person made on a date other than the trial date may be used as evidence in lieu of a statement made on the trial date, unless otherwise prescribed in Article 321 to 328. This is a very complicated code, complicated text, but this is like so. If the offender killed the victim, here is eyewitness, Mr. A. The Mr. A says saw the situation, the fact, and Mr. A tells his friend, Mr. B. Mr. B, Mr. A said, yesterday I saw the criminal, the victims are killed by the offender with knife. He stabbed. The Mr. A says, Mr. B. The Mr. B admissible as a witness. The Mr. B themselves go to a criminal court as witness, or Mr. A had written the fact in the diary. The diary admissible as affidavit evidence. That this diary, the prosecutor can bring up the criminal court as evidence. As a result of a hearsay rule, the Mr. B's cannot be positioned the witness, and this diary is not is prohibited to bring up as evidence to the criminal court, because the cross-examination is not enough, is not effective, even if the Mr. B comes to criminal court and this diary is brought up as evidence to the criminal court. But the defendant, the defendant and the attorney can't carry out the cross-examination effectively. So the hearsay rule, as a result of the hearsay rule, Mr. B and the diaries are not prohibited to bring up as evidence to the criminal court. That is the hearsay rule. It is, of course, as you might presume, these rules came from the United States. As I said before, now the criminal procedure law in Japan was introduced by United States. So these rules are in the criminal procedure law of Japan. This is a very important rule to correct the fact finding. Okay, summary. The work criminal justice system is good, and now the situation, the current situation of criminal justice system in Japan is very good. The safety society is carried out, the speedy trial is carried out, and the certainty of punishment is also carried out. So in terms of these points, Japanese criminal justice system goes well. So especially high guilty rate is very, very proud. And the Ministry of Justice very, very proud of it. But the problem is quality of criminal justice system. I think, in my opinion, not quantity, but the quality is a very, very problem. The accordance, which means our criminal justice system is carried out accordance with constitution or due process of law or not. This is a very important point. And several point important system and politics is a system. There is our criminal justice court is a three-tier system. We have three chances to examine on criminal case. And the Saiban system, the citizens can take part in the criminal justice system to decide the sentence whether not guilty or guilty, like American jury. Of course, Japanese Saiban system and American jury is slightly a difference, but the jury system is a very, Saiban system is almost the same as the jury. The expand of public offender system, it is a very important point to protect the right of the defendant. And the video camera recording the interrogation, it is a very, very big important, very important point is to make the correct the interrogation. The principles, the due process of law and the presumption of evidence and the several fact-finding rules, as I said, explained. This is a very, very important point. The problem is, to accordance with the due process of law and these principles, our just criminal justice system obey these principles or not. It is a very, very important point. So as a conclusion, our criminal justice system, the target is prevention of false charges. We have to avoid the misjudge and the false charges, because if the false charges occur, the innocent person must be punished. And this is an injustice. So we have to avoid the false charges. This is a very, very important target in our criminal justice system and the criminal procedure law in Japan. Okay, that's all. My lecture is, that's all.
Okay, thank you. Okay, ladies and gentlemen, the student, if any question, you can ask direct to Professor Ueda with English, or if you have difficulty to say in English, you can answer your question. You can use the Bahasa Indonesia, and I will translate to Prof. Ueda. Please.
Okay.
Silakan kalau ada yang bertanya. Ibu dosen juga boleh, ibu bapak dosen nih. Silakan. Bu Ike.
So,
Ya. Ya, not in chat box maybe. Silakan kalau ada yang.
I have one picture here about the integration of Indonesia. Here you are. Sorry, wait a minute.
Oh, no.
Yeah.
Oh.
I had to look at the article of Newsweek. Wow.
Yeah.
Serious.
You know, this the phenomenon. Yesterday, I see the video that said the wife of police officer who have a brother, and his brother died in police officer during the investigation.
Really?
Yeah.
Oh.
Now she go to Jakarta, meet the general of the police officer. Maybe we hope that he will and she will have a justice, you know.
Oh, really? I have question. I have one question here to Indonesians integration. And do you have a video camera recording system? No.
I think this different. Maybe it's a good idea. The interrogation, especially in police officer, should be recorded in the camera. Because this is maybe will prevent attack from the police officer.
Yeah.
Camera in
Yeah.
camera.
Serious.
We use the camera installation in KPK, in what we mean the corruption agency, anti-corruption agency in Indonesia. But in police officer we have no that camera, you know, and maybe you in Japan divide the public defender and the private defender. That means the public defender, he is the public officer appointed by state or no?
Yeah.
Public defender appointed by state of Japan state.
Strictly speaking, the public offender is not member of Japanese government and the Japanese states. It is very difficult to explain. And of course, the salary comes from the Japanese government, and the status is indifferent from the Japanese government. And it's not also the public defender is not the officer of the Japanese government, not the officer.
Okay, but
independence over.
Ya. Oke. Silakan kalau ada yang bertanya silakan. Tukar pikiran atau boleh bahasa Indonesia nanti saya terjemahkan.
Apa kabar? Is there anyone of students who have been to Japan before? Are there anyone of students among you?
No, of course no. Okay, I think no.
No one come to Japan yet.
Yeah, I think not yet.
So
maybe after he or she hear your presentation and good picture, maybe they won't go to Japan. Yeah, good country. Yeah.
Now, because of the COVID-19, the Indonesian tourists, they are not Indonesian tourists in Japan, in Sapporo also at all. But in normally, there is a LCC, low-cost carrier between Indonesia and Japan. So there is lots of tourists from Indonesia to see the snow or to eat the Japanese food.
Yeah. You know, in Indonesia too, we have limitation to journey. Yeah, because this pandemic. Yeah.
Genau.
Some place is sometimes is increase the number of infection of COVID. Yeah. We now in Jakarta today is very high COVID infection, but in Bengkulu is relative safe.
Good. Also, the students of Indonesia, the Bengkulu universities, what kind of occupation, what kind of work do you are you going to get after the graduation of school? Prosecutor or judge or attorney or banker, and work in enterprise?
Yeah. Of course, in the master student, almost they are already have a job. So I tell you, now here we have 40 students to hear this lecture. There are judge in this court, and the police officer, the chief of police officer, Mr. Pahala. Good afternoon. He chief officer of this not perfection. Cyber Takamasu, like Takamasu, like the district.
Yeah, that's right. Yeah.
Another. Oke, Ibu Ika mau tanya silakan. Enggak, ininya enggak. Mute. Speaker, Bu Ika speaker. Speaker, Bu Ika. Excuse me. Somebody will ask you, but he not take speaker, Bu Ika. Speaker, tolong Bu Ika. Enggak kedengaran. Speaker is not okay. Speakernya. Halo, please, nggak kedengaran tuh, Bu Ika? Some problem with its speaker, her speaker.
That is also okay.
Okay, connect. Okay. Also, they are from the Ministry of Justice, a branch of Bengkulu Prefecture. Of course, the bankers, there are some bankers, and some of them is the local district government, you know.
So, do you have a bar examination in Indonesia to become a lawyer and judge or a prosecutor? Do you have a bar examination?
Yeah.
National bar examination.
Yeah. For example, if like become a lawyer, there should be 2 years after graduate and training period, and after 2 years, there should be examination by the bar association.
Bar association.
After the pass of the bar association, he or she will practice as lawyers.
How is the passing ratio of bar exam? So, I mean, how many people, how many examinees can succeed in bar examination? How is the percentage?
But before they pass, they should be training by one training. Of course, that's not all of the student will pass the examination. Yeah, I don't know.
Please check the chat box. In Indonesia, I can't understand.
Yeah, maybe. Please, I did say, please read your answer, Bu Herlita Erika, in chat box.
Yeah, I read it now. Of course, I can't understand the Indonesian. So, Manggiking Perutani Nanta bisa
ditulis dalam chat. Dalam chat. Okay. Ya, saya maybe the audience will ask something. He or she can write in the chat box. That means.
Please write the question in chat box.
Yeah. If anybody will ask, okay, silakan. We have 5 minutes more. Yeah, if you have a question, please read in chat box. Okay, silakan.
Of course, if you have a question, if you students some questions, please contact me in email, and Haramban-san tell the students my email address. So if you have any questions, please contact me in email. So of course, I'm looking forward to meeting you in Indonesia next time.
Yeah.
I haven't been to Indonesia, not yet. So
Yeah.
absolutely and inevitably, I want to visit the Indonesia, Bengkulu University someday.
Maybe the pandemic fast go from this country, you know. 1 year is too long. Stay in not go anyway. Yeah.
Now I'm very
This is one. This is one. Maybe this is the last. In chat box you can see.
If it is possible in Japan, the offense like murder can be finishing police officer. If it is possible in Japan, the offenses like murder. No, no. There is no possibility to become a police officer.
Oh, the police officer cannot stop the case?
No.
Yeah. Yeah. But maybe in Indonesia, like I tell you, we have the customary law. Some case, they will stop in police officer, but the requirement is that case should be settlement by the hukum adat, customary law. After finish a settlement in customary law, they will bring to the police officer, and police officer say, okay, I will stop this.
Oh, unbelievable.
You know, every small society have that under court, the tribunal court. Yeah, tribunal court. Yeah.
This answer is impossible.
Impossible, yeah.
Okay, I did enjoy this lecture, and I'm very happy to meet the student of Bengkulu University. I'd like to express sincerely thank you very much from bottom of my heart, and I hope you come to Japan someday after the end of the COVID-19. I'm waiting for you. Thank you very much.
Okay, thank you very much, ladies and gentlemen, the audience, Professor Ueda. In the end of this lecture, we all of the students of Bengkulu University, I'd like to say thank you and appreciation. You have a time become our guest professor to teach in our university. Thank you very much. Arigatou gozaimashita.
Selamat jalan.
Yeah.
Dadah.
Okay.
Dadah.
Dadah. Goodbye.
Take care, my friend Harambam.
Okay.
I'm looking forward to contacting in Zoom next time.
Okay.
Take care of yourself.
Okay.
Hello to your family.
Okay. Thank you.
Okay. See you.
See.
Dadah.
Thank you. Oke. Terima kasih Bapak Ibu sekalian sudah hadir di dalam kuliah ini. Ya. Untuk yang kuliah HPM hari Jumat kita tidak kuliah karena sudah diganti dengan hari ini. Makasih ya untuk kebijakan perdana MHP yang pidana. Terima kasih MIH yang pidana. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.